it's Elena Saradidis, and today I'm with Jonathan Hacohen from the Chosen Lawyers podcast with Kormans LLP. I'm really happy to have you with me.
Pleasure, Elena. Thanks for having me. It's Jonathan, Chosen Lawyer, Chosen Life podcast.
Fair enough. We have corrections already. I'm so sorry we have no script. But I brought him along today to talk a little bit about real estate and the law and how do we get from point A to point B when purchasing a property. So a huge question that a lot of people have when they're buying a condo, for example, is what is the status certificate? What are we looking at? And why is it important to read it before purchasing a property?
Great question. With condos, it's funny because you have new condos, resale condos. So right away from that first point, people hear condos and they're thinking to themselves, okay, what does that mean, new or resale? So new construction hasn't been built yet, generally, not even a shovel in the ground yet. That's new. We'll put that off to the side for a second. Resale condos, so it's an existing condo building, could be 1 year old, could be 30 years old. You want to buy a unit in that building and you're saying to yourself, okay, is this a good building? Is this a good unit? Should I be buying in here? And thus the status certificate package. So when you get that package in, usually the seller will get it ahead of time now because they're expecting like a bazillion offers, unfortunately. You know how it is, right?
Definitely.
Elena calls me at midnight and she's saying, hey, I'm putting an offer at 4 a.m. Can you review this quickly for me? So
I've never done that.
Right. So we get this nice thing called a status certificate package. So first of all, it's got a letter in there. It's about 4 or 5 pages long usually. Outlines the unit, what are you paying for common expenses, is there a parking, is there a locker, is there lawsuits, what is the reserve fund, so how much money is the building holding in the back in case major repairs in the future. And then we get a whole bunch of attachments with it. So the budget for the building, we have the financials, the reserve fund, the rules, regulations, the declaration, the document that created the building, what year that was done, how they set it up. So lots of great information. So bottom line is we want to know, is this building managed well? How are the financials? Is this unit good? Are we getting what we're expecting? And then we make a decision whether we're putting that offer in or not.
So what would be, for example, like 3 red flags when looking at a status certificate that if you find these, you automatically say do not buy this property?
Good question. Just 3?
Well, you can do 5. You can do more.
No, let's do 3. So one of the first things people look at always is the reserve fund. That seems to be a magic number, and they're like, okay, what should I be sitting on a reserve fund for this to be a quote-unquote good building? So with inflation and everything else, the threshold used to be, regardless of the size of the building, how many units there were, people used to say $1 million in reserve fund, that's good. Well, $1 million ain't what $1 million used to be. Sure. So now you'll start to see, depending on the buildings, $2 million, $3 million. It could go up to $7 million for some buildings if you're, if you got a 60-story one, for example. But we want to see a good reserve fund. I want to see the study itself. It was done, so they do them every 3 years. So I want to see, is it a recent study or not? Is a new study coming out soon? And how much money are they putting into the reserve fund every year? What is the total of the reserve fund? And is it matching as far as where the building is at and where it should be at? Giant red flag number 1 is you got a negative reserve fund or a very, very low reserve fund. That's telling me that the condo building is not taking enough money so that they're able to pay for their day-to-day, month-to-month, year-to-year expenses, plus put money away for savings. So what's going to happen there is if we don't have money in the savings, we're going to have to either increase the common expenses monthly or do a special assessment. So that to me right away is red flag number 1. Red flag number 2, very little known fact, but people's lifestyles. I want to know these buyers. In our case, we're going to go purchase a condo unit, and what is our lifestyle like? Do we have pets? And the importance that people place on their pets. I'm a dog owner. I have my Shih Tzu, Ollie. I love her. Chosen Ollie on Instagram, by the way. And are we going to be able to bring our pets or our future pets into our building? So some buildings have very clear rules saying no pets whatsoever, or no dogs allowed, or certain size dogs, and 1 dog, 2 dogs, cats, birds, aquarium, whatever it be. When people are very attached to their pets, as most pet owners are, if I'm not able to bring my pet into the building, that building is going to be a no-no for me. I can tell you how many times people buy into a building and they're saying, well, oh, I found out now, oh, I never thought of that, but I can't bring my dog in. My lovely dog of 10 years, what am I going to do? Well, you're going to have to think about that. So that's red flag number 2.
And to be fair, any real estate agent that you're working with should know that you have pets. And if you do have pets, they shouldn't be showing you buildings that for sure have pet restrictions. They should know this before even heading in, because definitely you're not leaving the dog at home. You're buying a new property, you want to bring it with you.
And a lot of buildings, when you walk in, when they have that clear, they actually put it on the front door. No dogs allowed. Mm-hmm. It's very, very clear. But sometimes they're hidden. It could be hidden in the rules, could be hidden in the bylaws. So a lawyer needs to be able to look in the right places in the right documents to make sure that everything is good as far as putting it out there. So if the client does have any kind of pet in their lives and want to make sure they can have them in their unit when they buy, we want to make sure that they can. Number 3 is generally the management financially of a building. So we look at a combination of that reserve fund we talked about, but the budget and the financials. The budget's telling me how much did the common expenses go up over the last year. So sometimes in the budget they'll actually put the percentage, sometimes they won't. You can do the math, it's very clear. We took in $1.5 million in common assessment and then went up to 1.6. What is that percentage increase? We want to know how much it's gone up by. Try to figure out year to year in the last couple of years how much the common expenses have gone up and how is the condo corp managing their monies. Very simple. You look at the last couple of years in the financials, revenues, expenses, are we meeting our obligations? And are we expecting that any big expenditures are coming, have certain costs of hydro, insurance, etc. they've gone up? Is the building taking enough money to manage their daily expenses, their weekly, monthly expenses, but also being able to put money away at the same time? So bottom line, you can see from 2 of the red flags, financials are really, really important.
For sure. Let's talk a little bit about new construction.
Please.
Now, when you purchase a new construction building, we all have a 10-day cooling off period where we have the ability to show the documents to our lawyer. What are you looking for when you look at new construction documents?
Great question, as always. And you always got great questions for me. It's amazing how many times you and I are talking. You have your clients with you as well. We get that phone call, somebody raises a question. When you have that question in your mind, ask it right away. Don't leave it, because when you bring it after the fact, sometimes we can have an issue. New construction is a perfect example. So right away when you bring new construction, a common misconception is that new construction is an automatic 10-day cooling off period. Yes, there is, depends on the type of construction. So condos, yes. So if there's nothing written into the agreement with a builder, you buy a new construction condo, you have an automatic 10-day cooling off period where you can think about it, marinate on it. But remember, it's 10 days, it's not 10 business days. So you expire on a Sunday, you're expiring on a Sunday. If you choose not to go ahead with that unit purchase, by 10th day, you have to be able to write to the builder sales office and say, I'm not going ahead with it. But new construction houses are different.
Can we add like a dun dun dun?
It really is. So you got to buy a new construction house.
Okay.
And what happens is people assume that there's a cooling off period. There isn't. So you got to make sure there's a lawyer review clause in there. Very, very, very key. Because you go buy that new construction house and you don't have a lawyer review clause, you're done. You're in. Unless the builder's canceling the deal, that's it. It's not changing from there. So right away from the first thing is check what type of agreement you have. Make sure you have that in there. So in the new construction house. In the new construction condo, the cooling off period is generally written into the schedules now. Mm-hmm. But what will happen is that you won't always see it. So if you, and people, and builders, some builders are relying on the fact that people don't know there's a cooling off period because they don't always bring an agent. You just go to the sales office is like, yeah, don't worry about it, just sign, it's all good. That's why it's very important to have an agent like Elena coming with you to the sales office, negotiating on your behalf and trying to get the best deal you can.
Yeah.
So then what happens now, then let's assume we have that cooling off period or we have a lawyer review clause. Then it's sent to me, what am I looking for? Well, one of the first things is I want to get to know my client. So the same deal may not suit another person, for example. So first question I say is, okay, you're buying this lovely condominium unit. What is your intention with it? Are you going to be living there? Is an immediate family member going to live in there? Are you planning to flip it? Are you going to rent it out? What are you doing with this unit? Because if someone's come to me and they're telling me, listen, this is my dream condo, I'm going to live in there for the rest of my life, so nobody else is ever going to go there, we probably don't have to negotiate an assignment clause for them, for example. Yeah. It's not going to matter, because if we go and negotiate an assignment clause that they're not going to use anyways, we can't negotiate on other things. There's only so much you can push a builder's office these days, especially considering how quick new construction is selling, right?
Definitely.
But if they're going to tell me, look, I'm definitely flipping this thing, I have no intention of living there whatsoever, we want to be able to have an assignment clause where they can go and sell that contract to another buyer. If they're planning to rent the thing out, you can't automatically rent out a new construction unit during the occupancy stage, because you don't own the unit yet. You have the right to occupy it, but you don't live there yet. If you don't have the right to lease, then what's happening is you're having that unit sit empty potentially for months. You're not getting a rental income from it, but you're paying monthly expenses. So if we need to be able to rent it out, we have to negotiate that out. And then aside from that is the closing costs. So when you go to buy new construction, the price is not always the price, believe it or not. If you want a little cheat sheet, there's something called a Terry-on schedule. That's a new home warranty program. Go into Schedule B, and Parts 1 and Part 2 of Schedule B outline all the costs on top of your purchase price that the builder can potentially charge you. So, and it can be substantial. It depends on the builder, depends on the area. So if you're buying, for example, a condo unit in St. Catharines, it's very different than the one in downtown Toronto. Downtown Toronto, your amount of adjustments can be 3 pages long. St. Catharines, probably 1 page long. So, but what the builder is doing is they're charging as many things as they can and passing on their costs onto the purchaser, and that brings more profit. But from a buyer's perspective, they're saying, I thought I'm paying $500,000, I'm paying $540, I'm paying $550 with all these extra costs. So between us as the agent and the lawyer, what are we doing? We're trying to negotiate with the sales office, the builder's lawyer, and we're trying to lower those costs as much as we can to get our clients the best price and to make sure they're getting the unit the way they expect it.
Definitely. Honestly, I couldn't have put it better myself. That's something that a lot of people go into pre-construction not realizing they have to look out for. I actually had a conversation with a friend of mine the other day, and she said, my parents are thinking about buying a property for the sole purpose of assigning it. And I told them, don't do it. And the reason why I told them not to do it is because assignment sales are very, very tricky. And if you already go in with the motion that you want to assign the property, what happens if the market shifts during that time? What happens if you're forced to close? You always have to be prepared to actually close on the property that you're thinking of assigning. Because if worst case scenario happens, you have to close on it or the developer is going to take away that unit. And there's no compensation back to you for not being able to close. They're fully closing it and keeping your deposit.
You know, it blows my mind how many cycles I've seen in real estate and how people have the mindset. When the property value goes up, oh yeah, I'm taking that appreciation all day. So I go buy a unit and it's 500,000. And now by the time I'm closing, it's worth 700. Well, I'm a genius because they went up by 200. I'm definitely closing that thing one way or the other. But what happens if the value goes down? Like you said, markets shift, things happen. Yeah, you signed a deal 5 years ago, and guess what? Your $500,000 unit today is worth 400. Well, if you're forced to close it, what happens is you have to go get something, a mortgage, right? Something called a mortgage. Most people can't buy it in cash. The bank is not dumb. They're looking at what the values are. They're going to appraise the thing, and they're going to say, guess what? This is worth 400. I don't care you paid 500. I'm going to give you a mortgage based on the value of 400. So never, besides the fact of the 80%, 20% of what you have to put down, there's also that 100,000 that you're gonna have to make up, and not everybody can do that. And I remember not that long ago, okay? We're not talking 10, 20 years ago, we're talking even 3, 4 years ago, where I've known people that bought 1 or 2 units, planned to flip them, thought they're gonna make a lot of money, and all of a sudden they're saying, oh wow, it's gone down, and now I have to come up with the difference, and I can't get the mortgage, I'm in big trouble, and now the builder's threatening to take away my unit, they're gonna keep my deposit, and they're gonna sue me for damages. So then they're saying, you know what? I don't think that's fair. I think the builder should lower the price. And I tell them, okay, well, business doesn't quite work that way because you want the builder to make up for the fact that the market conditions went that way. What if your unit had gone up by 200? Would you give that 200 back to the builders? That's not fair. The builder should get the 200.
Yeah.
So people only see it in one way. It goes both ways at the end of the day. Really, real estate at the end of the day, in some ways is a form of gambling when you're going to speculate. No different than how you would speculate on stocks. Except for the fact that if you're holding real estate long term, no matter the cycle shifts, in 10 years, you'll end up there even if the cycle went like this. That's the kind of idea. But if you're going to speculate on a deal and flip it within a year or two, we don't all have crystal balls, otherwise we'd be in Tahiti right now, right?
Definitely. What I can say is the reason why Jonathan and I actually started working together is because I had a lawyer that I was working with that butchered an assignment deal. Whenever you're doing an assignment, every single person doing the transaction needs to be on the same page. They all need to know what they're doing or the deal will fall through. A lot of people get intimidated by seeing the assignment paperwork and seeing that you have to assume the original purchase agreement and different elements of it that are a lot of moving parts. Most real estate agents don't know how to handle assignments. Most lawyers don't want to handle the assignments. So automatically they'll turn to their clients and just be like, it's too complicated, it's not worth the work, back out of the agreement, it's not worth it to you. But in some cases, it actually is worth it. So it is important to work with people that actually know what they're doing when it comes to assignment sales. Now, if you're representing a buyer on an assignment, what are you looking for?
So I'm acting for a buyer of an assignment.
Exactly.
So that's one of the things about assignments, which is great. I'm called in Toronto the assignment king. And I tell people, you can send me things other than assignments. I can close your simple deals too. You don't have to just leave me the crazy difficult.
Hey, you get all of them now, but you know.
That's fine. Like right now, for example, I've never had more assignments in my life than right now. So right now in my office, probably have about a dozen assignments going of different degrees. And one thing people have to know is it's a very different consideration if you're acting for the new buyer or the old buyer. So the terminology, somebody who bought the contract, the original buyer, and now they're flipping it, they're the assignor. They're giving up the contract. The new buyer, the person receiving it, is the assignee. When I'm negotiating for an assignor and assignee, very, very, very different considerations.
So let's say you're on the assignee.
I'm the assignee side. So one of the first things I get that assignment deal in, I'm flipping right away, page 1, page 2, that HST section. So HST is really, really key. I'm looking, is HST included in the price or is HST in addition to the price? Not talking HST rebates right now. So right now with assignments, there's so many tax considerations we could be talking about. And there's always gonna be something called the HST rebate, which we can talk about in a second. But the immediate thing I'm looking at is HST included in the price. Why? Because potentially the assignor, the person flipping the unit, may have to remit HST out of the assignment price. So I'm looking from the assignee's point of view, are they gonna get charged for that part of the HST? If it's HST included in, right away I'm feeling better about this deal. Then I'm going to look into their schedules, and Schedule A is where you have the extra terminology, and Schedule B is where we have the financials. Bottom line, what I need to know is, when is the money due? If I'm acting for an assignee, I want to give the money as late as possible. Why? Because my assignee is probably needing their mortgage monies in order to pay the money to the assignor. Because they're going to have multiple closings. But 2 closings especially is one with the builder and one with the person who sold them the assignment, the assignor. And if they have to come up with, let's say, $100,000 in profit, not everybody has $100,000 sitting in their bank. They probably need the mortgage to be able to do that. So I want to make sure they're paying their money as late as possible. And then from there, what happens from the HST perspective? What if our assignee, what if they don't get their HST rebate? What if the builder forces them to go and give the builder on closing, let's say it's about $24,000, and then they have to go apply for the HST rebate themselves, and what if they don't get it because of the assignor? Who's going to cover that? So that's something that a lot of people don't look into an agreement as a lawyer, but I do. Whereas when I'm acting for the assignor, I want as little responsibility as possible. I want my money immediately, as quick as possible, and go off into the sunset. And if possible, HST to be in addition to the price. Because if my assignor is going to get nicked for HST from CRA, they want to be able to go back to the assignee and saying, you need to pay it now.
Definitely. That's definitely stuff that people do not know about. I get asked this on a daily basis. You'd be surprised just because people know that I know how to handle assignments. So they'll automatically be like, well, I can just assign my unit. And I go, wait 1 minute, send me the contract. And someone actually sent me their contract the other day, and the assignment clauses are ridiculous. They're just like, the builder doesn't allow you to advertise anywhere. You cannot let anyone know that you're basically selling this property. Okay, if you can't advertise anywhere, how are you going to sell it?
Have you ever seen the letters that came from the builder's lawyers when you do advertise on the MLS? It's lovely. You are not allowed to advertise in the MLS. You better take it down in the next 10 seconds, or else I'm terminating this deal, I'm keeping your deposits, and I'm going to sue you.
Yeah.
I actually had one where they didn't even give them the opportunity. They said it's terminated automatically. You broke the deal, so we're taking over the unit. Too bad for you. We had to go on our hands and knees and beg the builder to not do that, and they relented. But we had to take that listing down immediately. But good question for an agent. I'm going to flip the table. You don't have the ability to list it on the MLS. You have a client comes to you. How are we going to sell this unit now if we're not allowed to be on MLS? What do you say as an agent?
It very much has to do with whoever you're working with in their database. They reach out to realtors that they know have volume of clients that work on assignments, because there is a buying market of assignment buyers. So I have my own database that has just a pocket of buyers that solely look for assignments. So whenever we have an assignment deal, we market to those buyers. We let them know that something's coming up, and if they're interested, these are the terms. We also reach out to other realtors that have clients that have assignments. I'm part of multiple assignment realtor pages and groups. That way that if someone does have an assignment, we advertise it, but we advertise it throughout our mini community. It doesn't go out to the public. So it makes it a little bit easier with builders. Definitely sometimes even that is too much for a builder. You have to also remember, you have to see in your assignment clause inside your pre-construction, are you allowed A, to advertise because they'll mention it, and B, are you allowed to assign, and do you need developer approval before you even start advertising, or do you need developer approval after you've picked up a buyer for it? because there is two different ways that they can phrase it. In some cases, you can't even start talking about assigning the property until the developer has signed off and said, you can now start talking about it. You can't advertise it, but you can start talking about it.
It blows my mind how many people don't read their agreement, and I've had realtors that went and negotiated for new construction and said, hey, I got an assignment clause. See, there it is in Schedule Z. I said, it says in there that the builder will give consent, but it can be unreasonably withheld. If you can unreasonably withhold something, that's the same thing as not giving consent whatsoever. So that's not a consent clause. So we got to make sure that we have a proper assignment set up where we're able to get it. And yes, the builder and developer will normally want to give consent, but not to unreasonably withhold it. That is a very key item. Number two on it is, what are they charging for the assignment?
Yep.
Because I've had ones where there's no assignment fee listed. It says whatever the builder is going to charge. And I have one right now, $50,000 for an assignment fee.
At that point, I'm closing. I'm not assigning it.
Right, because that's a lot of money.
Yeah.
And on the same token, the builder developer is not dumb. They know if you're selling by assignment, you're probably going to sell for more money, and they might as well take a piece of it at the same time. So the point is, when you're going with Elena and you're going to that sales office and you're negotiating from day one, we want to be able to assign it, and we also know how much we're paying for that assignment, and having a cap on that assignment fee is huge. Because I can't tell you how many times, Elena, I have a signed assignment agreement. The assigned order assignee found each other somehow, negotiated, went through this whole charade of signing up an assignment agreement. We're good to go. We waive our conditions. Now we're going to go get builder consent. And builder says, no, you don't have the right to assign it.
Yep.
And what did we bother doing this for? So absolutely, please make sure you're able to get consent before you even bother going to find an assignee.
Yeah,
It's
and it's
ABC.
not just that too. There's a clause in it. I was reading one the other day, and the clause was so ridiculous. It was also on top of the fact that you need to jump through all of these hoops. At the bottom, it stated a line that basically said, even if you found an assignee, you've sold the property, no problem, we gave you consent, all is great, you have no more liability for this property. No. Even if you sold it to someone else, you collected their deposit, everything is done, the other people are set to close. If they can't close, you need to close.
1,000%.
So you can't even fully assign it and wash your hands out of it. So like, you have to read the document. It's not as simple as just like, here, sign here, no problem, 10-day cooling period, I can decide whether or not I want the property or not. No. You need to figure out at that moment, what are you getting yourself into? Because it's a lot more than just signing the paperwork, handing the deposit, and thinking now I have 10 days to figure out if I still want that unit or not. You have to figure out if you want that unit and how badly you want that unit. And are all the terms in the agreement satisfactory to you? Another thing that people don't pay attention to, the development fees. They'll get so excited. It's capped. The development fees are capped. We're all good. And I'm like, okay, great. You went to the sales center, you bought a unit. They usually come to me after the fact too, and they'll say, can you either assign it for us? We want you to rent it out for us. We're thinking of closing on it and then selling it. Can you help us out? No problem. I look at their agreement and I look at where they said that their development charges are capped. Their development charges were not capped. It says a capped amount, but then on addition to it, it says that they're responsible for a bunch of other fees.
And those aren't capped.
And those aren't capped. And
Right.
mark my word, the developer will come after you with every single thing on that line.
Right, and it's funny when people throw out this thing about development caps, levies, charges, believe it or not, it's not always created equal. So majority of the time we're talking about the increase in levies. So from the time you signed your agreement to the time you're going to close, whatever that amount of levies went up by, that's what you're being charged in most cases, and hopefully they're capped. They're not always capped, but there is some builders out there, not many, but they are out there and I've seen it, where they're not just charging the increase, they're charging the whole levies. So you're not just getting a bill for $5,000, $10,000, you can get a charge for $40,000, $50,000, $60,000, because you're getting charged for the whole thing because you didn't read it properly, nobody explained it to you. So very, very dangerous there. But let's assume that it's just the increase in levies, and let's say it's capped. Well, if you're gonna go assign it though, gotta read the fine print, because on a lot of cases in the builder agreements, it says, here's the amendment, and yeah, we agreed to cap it as long as it's for the original purchaser. As soon as you assign this thing, all bets are off, no more caps, good luck, we're now charging you from scratch. And it's there.
So that's why it's super important to use a real estate agent that has done assignments, that has done new construction, and it's super important to use a real estate lawyer that is very familiar with what goes on when you're doing an assignment deal or when you're doing a new construction deal.
On assignment deal, I always say you have to have, every party has to hit, like you said.
Yeah.
You have to have two agents, two lawyers, and everybody's be on the same page, and everybody's got to be working hard and understand what's going on. If one party, one professional is not professional and doesn't understand the process, they can put the kibosh on for everybody. I find that no matter if I'm acting for an assignor or assignee, I'm having to teach the other side every time about it because they just don't have experience in it, and they're scared, and inexperience or lack of knowledge can kill a deal, and there's no reason to kill it as long as you can understand what you're doing with it. So it's up to us as professionals to teach the other professionals so we can make sure it gets done. Absolutely.
Well, definitely. Actually, one of the first transactions I ever did as a real estate agent, I was representing the seller of an assignment.
Okay.
And that deal was probably one of the hardest deals I ever did, but it was a lot more complicated than it looks because A, one of my first transactions ever, and B, the person was forced to sell it with the developer's real estate agent. They had to. So now we're looking at a real estate representative who bought a property, who wanted to assign the property, and they get me, brand new in the business, sell the assignment. And of course, little go lucky me, needed to figure out everything I wanted, everything about assignments. I went up to every single person at my office. I went up to the development coordinator. I asked her to teach me how to write them. I wrote up all the assignments for every single person at my office. Like, there's no way this real estate agent is gonna think that I don't know what I'm doing. I need to represent him properly.
Right.
That deal fell apart 3 times. Not from anything I did, but because the real estate agent on the other side or the lawyer on the other side didn't know how to handle assignments. And no matter how much I handheld and I asked them all these questions before we got into the agreement, it still fell apart.
Yeah. You have everything has to hit off perfectly to get assignments done at the end of the day, bottom line. I remember I had one transaction and I knew the lawyer on the other side. And guess what? He had 3 times the amount of experience as me. He's been doing this forever. He was a lawyer since the 70s. And you know what he told me? I'm putting the kibosh on this deal. And I said, why? It's actually a good deal. Everybody understands everything. It's really simple. This is not a complicated one. I don't want any possible exposure. I don't want to deal with assignments. That's my policy. So if it comes to me, my automatic is no. I don't even have to look at the assignment. And I'm going to make sure that they do another type of deal, a resale one. I said, I don't think you're being responsible for your client. I don't think that's fair. The assignments are there for a reason. You tell this to your client, they may not get inventory, there may not be another unit to purchase. This one's available. Let's work together and let's figure it out. So, but you, again, even with knowledge, you have to have somebody willing to do it.
Yeah. And a lot of people just don't want to do the homework. It's one of those things where instead of a transaction being 5 pages, it's 180 pages. And how many people do you know want to do more work?
And how many times in assignments, you also have to look at it, it's not just a typical purchaser. It's usually a new purchaser. They've never bought anything ever in the world, so they don't understand real estate altogether. Now, they're buying new construction, so they have to deal with that and how to work with a builder. So that's a closing right there. Then, not only is it going to be one closing, it's going to be 2 closings with the builder because there's going to be something called an occupancy closing where they're going to be living in the unit, but they don't own it yet. So they got to close twice with the builder.
Plus they pay a fee when they're doing occupancy.
Oh, yes, they do. And people don't always get that part of it. So now they're going to have to pay this monthly fee to live in there, but they don't own the unit. And then to top it all off, they have the closing on an assignment with the assignor. So there's so many levels of closing, so many monies flowing, and they've never done real estate before, and they're doing the most complicated one. That's my typical assignee. I love it.
That's the fun part?
That's the best part of it.
Oh my goodness.
Yes.
It sounds, honestly, a lot of real estate is a lot of hand-holding. You have to walk your clients through a lot of these things because you're looked at as the expert in the field. It's not them. They don't know what they're getting into. They sign up and they assume that everything is going to be cut and dry and their friends made so much money assigning it, so why can't they make so much money assigning it? But their friend bought in a different development. They had opportunity to assign it at no fees or to use their own realtor or to not have to pay crazy fees. They don't look at it that way. They look at it as it should be the exact same because my friends have done it.
And also, their friends may have had a professional with them and got everything in writing. One of the things about new construction, never mind just assignments, just new construction in general, how many times have I gotten those phone calls? I was at the sales office, the salesperson told me, don't worry about it, it's gonna be fine. And they just went along with it, and then they contact 2 years later. I was told I was getting this finish. I was told I was getting this cap. Oh, that person doesn't work here anymore. No, that wouldn't be the case. Translation, get it in writing. If you don't get it in writing, it don't mean squat at the end of the day. Sure. And there's a lot of verbal promises, and people say, oh, you misconstrued. I never said that. I never said it that way. So when you're talking about real estate, you're talking about law, you're talking about agents, make sure when you're negotiating something and you're promised something when you buy new construction, get it in writing. Even get it when you get that email when the sales office writes back and says, yes, we confirm that you're getting this fireplace. At least we have something in writing to go by versus I got a verbal promise. Yeah. So watch out for that, please.
So let's flip a little bit. We did
Sure.
new construction, we
Okay.
did resale. Let's talk about buying and selling a house. What role do you play when people are purchasing homes?
What role do I not play? Right? So at the end of the day, I like to use sports metaphors. So for example, in baseball, right? In baseball, it's a 9-inning game. You have a starting pitcher. You're the starting pitcher. You come out. You pitch the first 7 innings of the game. You're making sure that we set up the game. We're winning the game. And then I got to come in as the relief pitcher. I got to pitch the last couple innings. I got to make sure that we win this game and we close it. So that's one of the funny parts about a lawyer and a law firm at the end of the day. You know, by the time we get it, the agreements are all signed, mortgages are obtained, but we got to get the thing closed at the end of the day. So, and especially when we're buying and selling, that goes into a whole different ball of yarn. So the complexities, especially if you want to buy and sell on the same day, that's my rule number one. Don't buy and sell on the same day if you don't have to. So many variables have to go right in order for that to be. So when a person's purchasing, for example, first thing they send me, when they tell me they're going to buy, can we use you? I tell them, send me the agreement. Send me the agreement as soon as possible. I need to be able to open up that file. I want to read their agreement. I want to know what's going on because there may be conditional periods. There may be, I may have to do certain searches. I want to know what type of property it is. So I need to get into the system as soon as possible. If things change all of a sudden when they get a question from the seller, can you change the closing date? Can you do an amendment? I always tell the clients, don't sign anything until I see it first. But in order for me to see it and be able to approve it, I got to have the original agreement on tap. So I got to know what's going on from day one. That's why as soon as there's a signed deal, make sure the lawyer gets it as soon as possible. If they're not sure, depending on the complexities of the deal, maybe the lawyer has to review that agreement before it's finalized. So put a lawyer review clause depending on the type of deal it is, right? And then from there, we start our process. We do our title search right away. We want to make sure what the seller has on title. They are the registered owner. Sometimes, you believe it or not, we can find all sorts of funny things on those title searches. There's another owner on there. There's a life interest where somebody has the right to live in the property as long as they're alive. There's multiple mortgages. There's funky easements. There's all sorts of fun stuff we can find on there. I do some sleuthing as well. I start talking to the client. I talk to the agent. Well, this thing is substantially renovated a year ago. They gutted the thing and they built it. Okay, well, I may be doing a title search at that point. We have title insurance, but I may also be ordering a building and zoning report because we may not want to have 1 million open permits sitting on our property. We know that they literally just finished the construction. It's a good thing to know. And if it's a high value property, we may get a tax certificate to make sure taxes are up to date. But we also have title insurance, so there's some thought process there from a law firm. There's certain things we order, certain things we don't, because we have insurance to protect the title at the end of the day. We keep in touch with our clients, make sure they're on track. We get them their opening letter. Getting that mortgage set up is really, really key. Do not leave that mortgage to the last minute, please, because mortgages take time. People meet with their mortgage rep. They need to be able to sign the paperwork. Has to go to a processing center. Then from there, the head office is going to send mortgage instructions to the law firm. Then we have to get going. If we're closing in 3 days, we can't have it that we don't have the mortgage instructions yet. So I've had people trying to shop the rates, by 0.001%. No, please go sign your mortgage papers. Make sure the lawyer has it. We need, depending on the property, we need property insurance set up. So we're getting clients on track, making sure their mortgages are set up, making sure they have their property insurance, getting the calculations done as soon as possible. Because it's funny, I have a lot of phone calls where people message me, my deal's closing in 2 months, how come I haven't heard anything? In real estate law time, 2 months is a lifetime from now. I'm dealing with the closings this week and next week. So for me, we contact the client, besides the opening letter and keeping in touch, we contact about a week or so before the closing in order to schedule the appointment, and we meet about 2 days before the closing to sign the paperwork and with the numbers and everything else. So everything happens in real time the week of closing. So we don't do things in 3 weeks in advance, 4 weeks in advance. I can't tell you how many times I've humored a client and signed up the papers 3 weeks in advance and things changed. Title changes all of a sudden. I'm going to add somebody onto title because my mortgage changed. And all of a sudden you got to redo the paperwork. So that's why you don't do things too much in advance. So we have our schedule of how we process things, and we want to just make sure everything's done right. So, but the key from the beginning, getting that agreement in, getting that title search done.
Clearly, I'm the worst client you've ever had because I feel like I leave everything to the last minute with you.
That's solicitor client privilege. I can't talk about it.
Fair enough. I'm not giving you permission to talk about it. Is that what we're saying?
Well, if you get permission, absolutely.
Oh, you'll talk about how bad of a client I am.
No, but you know what it is? It's because you work for your clients day and night, and as we all do, but the person you most neglect is you. So you're making sure your clients are on track, and you're like, oh yeah, I have to get myself on track as well. So you need an Elena to make sure Elena's on her stuff as well.
If you find one, let me know. I'll hire her.
Good luck with that. There's only one Elena.
Oh my gosh. Okay, so we talked about a little bit about buying new construction, buying resale, closing on a house versus on a condo. What happens if you are purchasing a property and there are occupants living there? Either it's the current owner that wants to remain for a few more weeks or a few more days after closing, or if it's a tenant.
Okay.
My
great
specialty.
Question. Great question. For legal reasons, we're not going to talk about any particular properties or particular people, obviously, but we're going to talk about this as an abstract.
We can talk about hypotheticals, right?
Yes.
What happens if you hypotheticals?
As your lawyer, we're not going there. So no, but in all seriousness, so that does come up quite a bit, and it's come up in different type of segments. So first of all, when we had from a COVID perspective, when things first started off, like over a year ago. And people were saying, oh, I'm in a condo building and the condo building is not letting people move out of the elevators right now. The elevators are shut down for the next couple of weeks because for safety, they're not letting people move in and out. That came up as a circumstance in a couple of buildings. People saying, I don't feel safe. I'm not going to go move into my new property yet. Or even regardless of health conditions, people just saying, I sold my place. And I thought I was going to either buy a place or rent a place, and it just hasn't worked out, and I have nowhere to go, so I'm not leaving now. That happens, certainly. That's one consideration. The other one is the tenants. Everybody loves residential tenants. And so you're buying a place, there's a residential tenant in there, the notice was given, and now they're not leaving for whatever reason. So maybe they'll argue that the proper notice wasn't given. So I can't tell how many times people don't give proper notice. They send an email and they think that's fine. No, you have to give it on the proper government form. And you gotta make sure the proper timing on it. So they're there from the 15th on, guess what? It's 60 days from the full month. So you gave 60 days from the 15th of the day, that's not sufficient. So people having their calculations properly. Really, really, really key. So from that end of it, it just becomes problematic as far as bottom line, I'm the buyer and I want to move into this unit, whatever it is, and now I'm going to be stuck with a tenant. What do we do? So let's backtrack. First of all, we'll take a look at the agreement. Okay. Did it mention a tenancy at all, and what happened? So I've had cases where we suspected that we're going to have a problematic tenant. Why? Because we were not allowed showings. It was very difficult to get showings, and the tenant told us, I don't really care that this is getting sold. I'm not leaving. So we can negotiate that ahead of time. When we know there's going to be a problem, it's great when we can put that in the agreement. So we have some options as a buyer. Maybe we're going to extend this deal every time until this tenant is fully out. So we're just not going to accept the property with the tenant. That's one option. Or we're going to take this property. We are going to close. But for every day this tenant's in here, seller, you're going to pay me a per diem. You're going to give me per day a penalty to cover my pain and suffering and my cost for getting this person out. Yeah. But we don't always have that luxury. So if we can negotiate that ahead of time, that's the gold standard. If not, we have a signed deal, and all it says in the standard verbiage, let's say it doesn't even talk about the tenancy. All it says in there, otherwise, we are to get vacant possession. We never discussed about assuming a tenant, and never discussed about adjusting rents and stuff. We just knew we're getting vacant possession. Now we're coming to 2 or 3 days before closing. Turns out the tenant's in there, not leaving. So I would be sitting down with the buyer and saying, look, we got some options here. We can negotiate this thing out now after the fact, but the seller can't give you a vacant possession. So but the problem is maybe the property value went up. So seller's saying, oh, well, I'm sorry the tenant's still in there. I can't give you vacant possession. So you know what, if you want to get out of this deal, that's fine. I'll go sell it to somebody else for $200,000 more. And buyer's saying, no, I'm not going to lose my equity in it. So we may have to work something out. If two parties are willing to work together, then we could say, okay, we're going to extend this deal for X amount of time until the tenant's out. Or maybe the buyer will just assume the property. Now it's their baby, and now they got to take over the proceedings to get rid of the tenant. That's the worst case scenario with it. Maybe we're going to do a holdback of monies. So we're going to say, seller's going to hold back the money, making sure the tenant's going to pay their rent every month until they leave. So we have a few negotiation items. But we have to consider in market conditions like this right now, Elena, when we have the hottest market we've seen in a while, and we say that every year, but this time it really is. It really means it. There's no inventory. Yeah. From a seller's perspective, they're going to say, it's not my problem. Either you assume this property, good luck, or I'm just going to sell it to somebody else, right? So we've encountered all sorts of things at the end of the day, so we have to know from day one. So when I get that phone call and I'm told I'm going to go buy a property and there's a tenant in there already, to me that's already a red flag. because there's always the risk they're not going to leave
Or not pay.
or not pay. They're going to say, you know what, the way it is right now, there's rent frozen, so I'm just not going to pay my rent, and good luck with it. So from a buyer's perspective, they have to think about it. They can have 2 properties, but, you know, and this one does not have a tenant, this one does. Maybe we take the one without the tenant. But there's also properties out there, Elena, where people want to buy as income producing. And they're saying, this is great. I want to have a tenant in there. They're going to pay my mortgage for me. It's fabulous. Then we have to make sure we put clauses in the agreement where we're going to say, we're assuming the tenant. This is the monthly rent. We're going to adjust for it on closing. So we can actually work for us in our favor where we want that tenant in there.
Definitely. And the one thing people don't really realize is what happens if it's a verbal lease versus an actual lease. And if you're assuming someone with a verbal lease, what should you be grabbing? Jonathan's laughing right now because I've pretty much put him through the ringer on every problematic transaction known to man because I tend to like the problem houses. I get better deals on them. But for myself, my clients are never put in this position. It's always me, if you've noticed.
Yeah.
Yeah.
It's like those people I know that love cars and they buy, you know, the wrecked cars and they're saying, I'm going to be able to fix it up. I'm going to get a good deal. That's kind of how Elena does it with real estate.
Hey, but I do get good deals and I get everyone out eventually.
You do eventually, by hook or by crook. Absolutely.
Yes.
Okay, so one of the things I had in my head that I was laughing about, why we want to have these clauses in our agreements, because in the standard verbiage, all we're saying is that we're going to have vacant possession. When there's going to be a tenant staying in there, very often I see buyer agrees to assume tenant. Okay. So now we take over the tenancy, let's say. What happens when that tenant files with the landlord-tenant board that the landlord has been breaking the law and owes the tenant X amount of dollars, or the landlord did this and this to the tenant? Guess what? We want a signed declaration from the landlord saying this lease is in good standing, there's been no issues, the tenant has not has come for anything, and if there is an issue, I will indemnify you. So we want to have some kind of clause inside of our agreement so that the landlord will sign off something as a landlord swearing that everything's okay. Now, if we can get the tenant to sign a declaration as well, that's the ultra gold standard, because one thing is you're relying on the landlord part of it, and then if the tenant does sue you, you got to go back and sue the old landlord. But if the tenant signed that the lease in good standing, I have no claims against the landlord whatsoever, we can put a clause in there that the tenant has to sign it, but then it's up to the old landlord to go get it.
Yep.
And they can't always do that. I've had multi-unit res situations where a person's buying a 20, 30 unit building. You're gonna go get 20, 30 tenants to go sign off? Not so simple. Because in their leases, it doesn't say that they have to sign it, and most will not agree to sign it. But let's say there's only 1 or 2 tenants, they may agree to do it. So we wanna have some protection measures in there because otherwise, again, you're assuming this tenant, you're assuming the risk. And guess what? People forget, it's not just the fact that they're paying or not paying. What if the tenant, in fact, has not paid rent for the past few months? What if there's an ongoing lawsuit from the tenant's point of view? As soon as you buy that unit and you're the new landlord, you're assuming that lawsuit, you're the one on the hook now. People forget about that aspect of it. So it should deter people from buying tenant properties. It shouldn't deter people from becoming landlords, but you have to put protection measures in your agreement saying, I'm starting from square one, there's no issues from the past, so now everything is good, and then we'll see what happens in the future. But if you're buying something without that protection, everything in the past can come back at you.
And you have to remember too, in Ontario, we have a lot of tenant rights, which means that if a tenant is living in the property and they're not paying a lot of rent, and the landlord decides to sell it, but you are purchasing the property for the purpose of renting it out, you have to inherit them. Unless somehow the previous landlord either offered them cash for keys or somehow got a form signed that says they're going to leave and they actually move out. But there's no guarantee and they have a lease. So you might be inheriting a property that instead of getting the $2,700 a month market rent that you were banking on when you purchased the property, you're getting $900 a month.
Right. And how many times I've seen landlord and tenants have a side deal being rebated back in cash, or I was paying rent in cash, so that was the real amount, and oh boy, yeah.
Yeah, and there's no proof of the rental amount, there's no proof of anything,
Nope.
And we're put in a very difficult position.
And I got another one for you also, just to add to it, is also, guess what, the tenant's also the handy person, and then they're also a quasi superintendent, so they've been doing odd jobs.
And the dog walker?
So,
did we forget the dog walker?
So now, beyond dog walking,
Oh my gosh.
they're fixing the roof. There's another tenant in there. They're the ones fixing items in their unit. So guess what? You're inheriting an employee now as well. Yeah. So that's where, when we're dealing with commercial properties, we'll have also a bunch of clauses in there. But when you're dealing, let's say, with you're buying a resale condo unit with one tenant in there, you're like, this should be very simple. Not always so simple.
Yeah. You have to very much protect yourself. Make sure you get a copy of the lease, and you can put that in your agreement too, that another version of the lease, or the lease will be sent to the landlord upon final closing or before closing, so we can review it. There can be conditions for that. And most, if they're not hiding anything, they shouldn't have a problem sending you the lease.
Absolutely. And when we're dealing with multi-unit residential, we can have, I want copies
Rent
of all
roll.
leases. I want financials, a rent roll.
Yeah.
So you have to write out for me, what is the monthly rent? What is the prepaid rent? Because also you're inheriting the tenants. Guess what? They prepaid rent. You're responsible now to pay them that interest. So we have to do these kind of calculations. Absolutely.
Also, did you put in the agreement that you get last month's rent? Because what happens if you didn't put it in the agreement and they're like, well, we're not giving you last month's rent. It's not in the agreement.
Well, and I've had ones where the tenant comes back and says, yeah, so I have last month's rent, so you better credit it for me. And it was never revealed. There was no credit given from the original buyer. Because what happens is when there's last month's rent, the seller is supposed to credit the buyer, because now the buyer is responsible to give that money back to the tenant. And if you don't get that credit, you could be out money, and where you're left going to small claims court trying to sue the old landlord, the seller.
Yeah, and sometimes that rental amount is not even worth going to small claims court for.
Usually
like
not,
the cost of going to court is a lot higher than the cost would have been to have just known that information ahead of time and requested it from the other side.
It's unbelievable how often in real estate people are saying, I'll just go to small claims court, no big deal. There's filing fees, you're gonna hire a paralegal or lawyer. I'm telling them, you're gonna pay potentially $5,000 to recover $2,000. How does that make sense? It doesn't, and that's what people count on, right?
There's things that you'll notice too when you go into the property, just the condition of it. If the tenants are living in there, do you want to inherit tenants like this? Because odds are, if they don't move out, those are your tenants. So you have to figure that out before you even write up the offer. You should figure out whether or not you'd be okay if they stayed. Because if worse comes to worse and you have to close, and you have to close with them, you need to make sure that you're closing on tenants that you'd actually want to have in your property.
I can't tell you how many times people have purchased buildings with multiple tenants in there. We're not allowed access into the units. Nobody pushed the fact. They close, and then they find that there's things wrong with the unit as far as from defects, damages, and they're saying, well, this wasn't revealed to me. Well, you didn't get into the unit. You chose to get it sight unseen. I tell people, I can't fix stupidity. I'm sorry. Like, if you're gonna want to buy something and you want to any kind of guarantee in life, you need to be able to inspect it. You have to go see it with your own eyes. You got to bring in an inspector and a professional and see what condition it's in. If you're choosing to take it sight unseen, you only really have yourself to blame in that sense. Because what can come back is you have this warranty saying that everything's in good working condition. The other argument back from the seller will be, it's in the same condition it was from day one. Since the date you signed the offer, nothing has changed, so you agreed to assume it that way. Including when the fact people have old home inspections, or they get an inspection report from the seller's side and they're saying, well, that's going to be sufficient for me. It's amazing when people don't want to do their own due diligence. So they get your due diligence. You got to make sure that you're actually the one checking it. You got to check the condition of the property. You got to check financials if you have to. Otherwise, going to complain after the fact, it's not always fixable.
It's also not always possible to get an inspection done. Sometimes you have to rely on the seller's inspection, but it all has to come down to what your risk tolerance is. So for example, and I think you've noticed this with me, my risk tolerance is pretty high.
Okay.
Yeah, I think so.
You're right.
I tend to go for the problematic ones, remember?
Yeah.
But
you know what you get yourself into.
Yeah.
But you're a professional.
But that's the difference. I know what I'm getting myself into, and the point that I'll call Jonathan and be like, look, I'm almost 99% sure that this person hasn't paid their taxes. Like just by the way that the house is, I'm getting an off feeling by the other side. Can you please run that? Make sure that they've paid their taxes. Like I know I'm gonna have the warranty on it. I know I'm gonna have title insurance, but there's certain things that I want you to check because I have a feeling that none of this is right.
You've had some where you said to me, I don't think title's gonna be right to this property. Can you go pull the title for me? Let's go take a look at it before we even put the offer in.
Yeah.
And sure enough, the person who claimed to be the owner is not the owner. Or something is wrong with the property. In fact, you know, the way it's described, it's not this property, it's the next door property because they own multiple properties. So there's things we have to look at absolutely ahead of time. The more due diligence we can do ahead of time, the easier our lives going to be, certainly.
Definitely. And again, it's stuff that you need to be working with the right people so they're able to guide you in these situations because you'd be surprised how many people go in, put in offers, and they don't know what they're actually getting into. Like, you remember, we did a purchase once upon a time where I inherited the basement tenant. We were not allowed to go see the basement. All the problems you can find from the basement. The majority of the problems you can see when you go into the basement. Not allowed to see the basement. I was not allowed to meet the tenant. The tenant refuses entry, apparently, because they're afraid of COVID. They used COVID as the excuse for us not being able to see the basement. And there were 6 offers on the property. Keep in mind, this was almost a year and a half ago. Yeah. 6 offers on the property. I was probably the only real estate agent that was putting in an offer on it. We can't guarantee, but I'm sure there wasn't 5 other real estate agents putting in offers. So 5 people were putting in offers on a property that they never saw the basement, that they didn't know about the tenant, that they didn't know anything to do with that. What happens if I didn't get it and one of them got it? And we found out too, through further investigation, the tenant wasn't paying rent. So we put in stuff to protect me, of course, but if they were going into the situation, they weren't working with a me, how would they have known this? How would they have protected themselves from it? When you get the document, it's already too late. It's a firm deal. They were competing with 6 people.
I can't even tell you how many times. So it's funny about clients, you know, when they're going to put the offer in, all they're blinded by is, I want to get that property. I don't care what it takes. Put the offer in at midnight. I love this property. I've seen the pictures online. This is my dream property. Get me into that property immediately. And then as soon as the deal is firmed up, okay, now let me look for everything that's wrong and let's fix it. Where were you at the time the offer went in? I tell people, you went into this property. Every little detail now, you're telling me, I opened up the fridge, it looks like there's rust, I pulled a carpet, I see a defect in the flooring. Where was this person when this person went to put the offer in? Why did you not do this ahead of time? Because it's so much easier to deal with it when you're going to put the offer in. But they said, oh, you know, I can't do that because there were 6 other offers, there were 10 other offers. I'm right. So then you already knew ahead of time. Now you're in it, and now you think you're going to be able to fix it. No, you're
assuming
in most
the
cases,
issues.
you're getting the property, and I don't care if the warranty says everything's in good working order. It's in the same condition it was in when you put the offer in. So the way you're going to be so checking into the minute detail now, do it when you go in, when you go put the offer in, just so then it's realistic that you know the expectation is that's what I'm getting. Can't tell you how many times people have not done home inspections at all. And there wasn't a home inspection report available from a seller. And they're saying, well, I had no choice because there were 20 other offers. And if I put in a home inspection clause, I'm not getting the property. Well, then there is your answer right there.
Well, what I usually tell my clients when they want to remove stuff like that is you have to go in with the mindset that everything is wrong. That's the mindset you go in on. And if you can take in that you're purchasing the property at this price and everything that could be wrong with it is wrong with it, no problem, let's write up the deal, we'll take out the condition. But you have to be okay with that. You have to be okay with finding out after the fact. If you're going in without any conditions, that the roof was leaking. And maybe you couldn't tell that the roof was leaking because they fully painted over whatever watermarks they had, because they'll do it. There's a bunch of red flags that you see when you walk into properties or enough properties that you'll notice, like, oh, it smells like fresh paint. Were the walls painted green before and they wanted to paint it white so they could get more money, or are they trying to hide something? Oh, it looks like there's no knob and tube in the basement, but did they run it up all the way up to the 3rd floor? Have you checked the electrical on the 3rd floor to see if there's knob and tube there? Most people don't look at that. So the difference when I go into a property, especially one that my clients are planning to purchase, we do an inspection of the property from the outside. We go across the street, we look at the house from the outside, we look at the roof, we look at every potential problem that the house could have. We walk around as if we can see the most possible, because we don't have an inspector with us. There are things you can see just because you can see it. And they have to be working with people that know where to look. And believe it or not, my experience in looking for problems is because I purchase problems.
So now you know what to look for, right?
For myself, I usually don't have conditions because I want to get it for the best price possible. And I go in with a mindset that every single thing is wrong with the property.
That's a healthy attitude,
And
absolutely. Absolutely.
even if you get an inspector report in, most people don't know this, the inspection report will only see what they can see. They can only see what's in front of them. They can't see what's behind the wall. They're not cutting holes and seeing what's behind the wall.
And the limitation on their liability is up to the cost of the inspection fee.
Exactly,
So,
and they write that in the fee.
Right. So for the realtors that are watching this right now, one of the things I want to say is, I can't tell how many times I've had experienced realtors and they bring in clients who are their friends. They know these people, could be family members, and things go wrong. And they say, I sat down with them at Starbucks. I told them about this. Now they're denying that I ever had this conversation. One of the things are for realtors with your clients, we know we love our clients, we trust our clients. But after you have those difficult conversations, put it in writing. Send them that email. I know it's not the easiest thing to do, but hey, it was great seeing you at Starbucks last night. Remember I told you that the roof looks kind of bad and there was a bunch of issues and you don't want an inspection report? My advice to you is not to go ahead with this purchase unless you got an inspection report. You're going despite my advice. No worries, but I'm again making it clear that I put this out to you and told you that these are things you have to consider. Why are you doing this? Because you have to think, if things go wrong and the client's really upset, they may go to the realtor and say, hey, you never told me that. And you'll say, yes, I did. And then it becomes he said, she said, right? Well, we're gonna go to court about it. There's that email from November 24th, 2019 saying, great meeting you at Starbucks and here are the issues. So you have to have everything in writing.
So what I usually do, and I do this, well, okay, you want to take out the condition, no problem. Everything's signed, no problem. I have not submitted the offer until I send them a message and I say, please confirm you are understanding the liability that removing that offer opens up to you. Like, are you okay with all of this? As long as you confirm, I will send in the offer now. And they'll say, I confirm, no problem, the offer gets sent. But until I get confirmation, once again, so not only did we have the conversation, not only did I explain everything to you in writing, I then go one more step, and before I submit it, I ask one more time. Great. Please tell me you are okay with everything that we've discussed, that you understand that if we take out a finance condition and you can't come up with the difference in price if the appraiser comes short, you understand what that entails. You understand that you have to come up with the difference. You either have to close privately, you got to get a loan, you got to get something to close on this property because there's no other option. You have to close or they'll sue you.
Yeah.
So I have this conversation, I put it in writing. I tell them to confirm before I even send it off because again, if shit hits the fan,
yes,
you want to be protected and you want your client to feel like you've done everything in your power to protect them.
You have your mind blown?
Oh my God, I'm ready.
You ready? Okay, so part of my initiative when I came to Kormans was I wanted to go paperless and virtual. Mm-hmm. No more paper, don't want to see paper, don't need paper. In December of last year, we finally made the last step where besides the virtual meetings, no more printing off paper and signing, scanning, shredding. Now we sign electronically. But in order to sign electronically with people, I have it in a virtual setting and I videotape those appointments. And funny, because a lot of lawyers will be very scared of that. They're saying, I don't want to be on camera. I don't want to admit things. No, I embraced it. Why? Because I'm confident in myself and what I tell a client and what they're hearing from me. And I just had this appointment, for example, the other day, where a client was telling me, they tell me one story, and all of a sudden on tape, they're telling me a different story. And I'm telling them, that's a very different story in what you're saying. And are you asking me to break the law right now? Are you asking me to cheat on taxes? And I put it out there on video. Because why? Because at the end of the day, when they're hit with a big bill potentially, they're gonna come back to me, you never told me, really. I have it on tape. We're gonna play it back exactly. And I said, and I do the same thing. I take my pen, that I'm taking a couple notes, I throw down the pen. Okay, for this appointment right now, we're not signing anything else until I'm making it very, very clear where we stand on this transaction. And either you're gonna acknowledge it or we're not signing the papers. But you're gonna hear what I'm gonna say, you're gonna acknowledge back, you're gonna tell me if there's any questions, and we're not proceeding until we're all on the same page. No pressure. You want to stop the appointment right now? We can stop right now. We don't even have to sign anything right now. Yeah. I like the no pressure approach. But on the same token, I came to the point in life where I would sit in an appointment, I'd explain things to a client for an hour, they would call up their agent a day later, and it's like that appointment never happened. I told them about the common expenses. I told them that they have to set up with their property management to set up the payments for the following month. I told them about how property taxes work and how the bills work. The lawyer never told me that. Really, I can play the tape now. So it goes both ways, and at the same token, you have to feel really comfortable in your abilities to be able to tape that. But for me, it was, okay, I sent certain emails to put information out there, but I love the idea of being able to have the main meeting with the client is the sign-up part of it, because we have twofold there. We have to make sure we close, what amount of money we need to close, what papers were signed to close, and what happens after closing, and what we need to do. And now I got that all videotaped, so boom. And you know what? People were very receptive to it. They appreciated that very much. Because at the end of the day, the purpose of that appointment, it's not to get people in trouble. It's not to get upset. It's a good thing. We want to be able to close well. Clients need to know what is the expectation, what is going to happen, and then the communication back and forth. And that's why I embrace those appointments, and that's why I tape them.
Well, I think the best thing to do when you're ever talking with a client and you don't know something, even if it is being videotaped, not being videotaped, the first thing that you say is, I do not know, I'm going to find out for you. Mm-hmm. Like, that's the best thing you could possibly say, and I do think that it gets your clients even more comfortable with you because you're not just bullshitting. You're telling them exactly what they need to hear. I don't actually know this, but let me call an expert. And that's when you get calls from me at 3 a.m.
Yeah.
Or my mortgage brokers get calls from me, or my inspectors get calls from me, because no one knows everything. No one does. And I'm sure even you, like, there's a point where you're going to consult someone that you know with just because you're like, look, I need a second opinion.
And maybe something I don't deal with on a daily basis, right?
Exactly.
Yeah.
So there is opportunities in this industry where whoever you're working with needs to be confident enough in themselves to know when they have to look somewhere else, when they have to ask other questions to get you the most information that you need. Because this is one of the biggest purchases you're going to make.
But then right there, isn't it really important, the team? So when you have, let's say, a purchaser, we got the team of three, right? We have the agent, we have the lawyer, we have the mortgage rep. If the three of us work together really well, we can bounce ideas off each other. Everybody's in the loop on things. Things get done really well. How frustrating is it for you and I when we're at the last stages now and we don't hear from the mortgage rep, there's no mortgage, we don't know what's going on, and then there's no communication. Versus the mortgage rep that contacts us, instructions are coming in. This is what stage we're at. And then you let us know, by the way, an amendment's coming on the closing date. I let you know some papers came in from the seller. We all stay in communication, and then the client is best served on it.
Well, I think we had this case, recently where I had a client that wanted to amend their paperwork so they closed sooner because they needed to be out of the rental that they were in, and their closing date was just too far. They couldn't find temporary accommodations. We needed to move it up. And I remember asking them, I go, okay, no problem. Call the mortgage broker, call the lawyer. Either I can call them or you can call them. And we got to confirm with both of them that they're okay with moving the date as well. Then I'll call the other side and make sure the other side is okay with moving that date as well. Because the worst thing that can happen is we all decided to move the date, let the lawyers and the mortgage broker know after the fact, and the mortgage broker's like, we can't get the funds in on time.
Right, because
so we can't even close
because we have to do a whole new mortgage application now, and now we're starting from scratch. We can't do that.
Exactly.
Yeah.
So it is super important that everyone's on the same page. Even when my clients, sometimes they have their own people that they'd like to use, and for sure, they can use whoever they'd like.
Sure.
I usually tell them, I got 5 mortgage brokers, 1 lawyer that I use, and if you want to use the people I have, great, use them. I've used them all personally, so I know the standard that I'm referring to you. But if you want to bring your own person, that's no problem at all. First thing I do is I call them. Even before we have a transaction in place, I call the other side and I have a conversation and I say this, look, this is what's going on. We're looking at properties in this range. They've already been pre-approved for this amount. I'm most likely going to have to send you status certificates. We're going out to look on this date. I just wanted to touch base with you so you actually put a face to the name and you know who you're talking with.
Right.
And then after the fact, we get a property signed, we get all the deal done, I send it over to them. I always include a little, give me a call if you have any problems or we run into any questions, because in an ideal world, the clients never know there's an issue. The clients don't know there's an issue until we've solved the problem.
Right, because as a team, we'll all communicate with each other.
Yeah.
And for example, we may not know that there's something with the mortgage and the mortgage rep's already working on it. And in a day, it's fixed already, so no need to panic the client for no reason. Now, it's a fine line because obviously we don't want to spend days working on things and the client's not in the loop, and then comes the day of closing. Oh, by the way, I knew about this for 2 weeks, but I never shed the light on you. But on the other hand, if it gets solved in 10 minutes or an hour, that's the whole purpose of the team. So for me, real estate is about team, working together, communication, and then smooth closings.
Definitely.
Yeah.
Everyone needs to be working together. Like the whole mentality that it's us against them or them against us, it never works out the way people think. And definitely when everyone has the same approach and when everyone is working together to get the deal closed, it's a lot smoother transactions.
How about relationships also when it goes the other way? For example, for myself, I know the law firm on the other side, they know me. I can't tell how many times we have to do an extension or something or a holdback, and we've closed dozens of deals together. The other law firm will say, because it's you did me a solid, I'll do you a solid. It's that kind of relationships to be able to have that communication. That's why it's really important to keep in touch with the other side. Same way, I'm sure if you know the realtor on the other end of things, we can talk about it in a different language versus somebody we've never worked before. So that's where relationships in real estate are really, really key.
Definitely. It's one of the most important things I would say, relationships. And most people don't know that. They think, oh my God, I can use my cousin, my uncle, my friend who does real estate part-time, and they'll be able to help me as much as a full-time real estate agent would do. And I go, full-time realtors, they all talk with each other. They have the majority of listings. If a property is if you want a property, who's going to get it? The person that knows the agent on the other side, or your cousin's best friend's brother who does this part-time?
Yeah. Or the family law lawyer that dabbles in real estate.
Yeah.
And what happens if an issue comes up and they do one deal a year? Maybe not the best route to go. It's funny. So be able to think this is your biggest purchase, it's your biggest investment. Why wouldn't you get the best possible team to be able to get it done for you? Absolutely.
Definitely.
Yeah.
So another question I wanted to ask is, for example, what happens if the worst case scenario happens? I know we've had a case like this before, that's why I'm bringing it up.
Give me your worst case
But
scenario.
let's say we bought a condo, the condo floods the week before closing.
Okay.
What do you do?
So one of the first things, any time there's a situation that comes up, our best friend is the agreement of purchase and sale, the APS. Let's go take a look at it and let's see what the wording is. So let's say we're just using the standard wording. There's nothing in the schedule about this. We didn't expect nothing. So if it's substantial damage to the point where the unit is substantially changed and it's going to be like that before closing, guess what? The buyer has the option to get out of the deal at that point. But otherwise, the buyer may agree to assume the property and be able to take the insurance money that's going to come in, because there's going to be insurance potentially to pay it out. So we have to know, first of all, what the agreement says. Then from there, what's the buyer's intentions with it? We got to keep communication. So we got to get on the horn with the seller's lawyer immediately. What is the extent? Did you get quotes? When is this going to get done? So I've dealt with it in many different scenarios. I've had a case where the buyer walked away. Like literally the unit is gone. Okay, The unit is gone. It's now going to take weeks and months to fix this thing. Okay, we're walking away from this thing. Fine. Another one, they said, okay, you know what? I'm agreeing to accept the seller's insurance money on it, and I'm good with that. Another one, we held back a substantial amount of money because we're not sure if the condo corp is going to cover their insurance or the homeowner's insurance. So we're going to hold back $50,000 until everything gets sorted out. And from that $50,000, the bills are going to get paid. And then once the buyer gives the okay, then the rest of the money can be released. So there are various options. We just have to look at intentions and what the agreement says.
So what happens, and maybe this is a better question for a mortgage broker as well, but what happens if it's a house and the house catches fire before closing? There's now no property on the land.
So you mean like the house burned down?
The house burnt down.
Okay. So, well, when they give the mortgage, they're giving it on a habitable house.
Yep.
So somebody's going to be able to be in there. Your mortgage is going to change substantially at that point. We definitely bring in a mortgage broker. They'd be, turning right now green and blue listening to this story. But I've had cases where I've heard that somebody buys a house with the intention to knock it down and then rebuild. Well, it's one thing when the house is on the property. When you're going to go tear down that house, you're supposed to let your lender know because they lent you the money on the basis there is a house on the property. So technically you're committing fraud if you're doing that. So you don't want to do that.
I like how you whispered that. The mic still picked it up. Don't worry.
But we know it's there at the end of the day. But it's all about truth at the end of the day. Because one thing people forget, I find out that the house burns down when I'm acting for that purchaser on their mortgage. I'm also now the lawyer for the bank as well. So on residential deals, the same lawyer is the lawyer for the purchaser and the bank. So I'm the lawyer for the bank. I can't withhold information from the bank because they're my client too. They find out that the house burned down. Why are they upset? Because guess what? If that purchaser stops making their payments and they take over the property, they don't have a property to flip and have a tenant in there. They're stuck with this burnt down, nothing piece of land. That's not what they agreed to lend their money on. They got appraised with a property on there, a house on the property. So certainly it changes the complexion of the mortgage. If the house burns down after closing, first thing is you're contacting your insurance company, then you're contacting the bank. And this is where people are, when it comes to closing resale homes, new construction homes, and they're telling me, why are you so stuck on me getting proof of insurance? Because on your insurance, it has to name the lender on the policy. Why? House burns down, guess who's getting the money first on the insurance? It's the bank. Bank's gonna get paid on their mortgage before you're recovering that money. You can't have the house burn down, claim your insurance money, and then the bank is saying, hello, I still have a mortgage here. So that's why we have to name the bank on there. So anyways, making sure we get ourselves set up from the beginning and making sure we're truthful about it. And hopefully our homes don't burn down before closing.
Just a random question.
But it does come up.
So I know that when I work with you personally, and when my clients work with you, the 2 weeks before closing or a week before closing, usually send out an email with a long list of, or maybe not that long, but a list of what you need to get done before you actually close.
There's listed various points. From the time we open up the file, which could be 3 months away from closing, we'll send an opening letter giving the clients the heads up, here's the things you have to start preparing, and then we'll have a reminder when it comes time closer to closing, that's about a week before the closing, saying, by the way, I still don't have your mortgage stuff, I don't have your insurance, note, I have to get post-dated checks. Depending on whatever I need, we let them know closer to, certainly. But it's also having that opening letter from day one, because clients want to know, hey, keep me in the loop, what's going on, they love communication. So having a good opening letter and having the expectations set out from day one makes a big difference, certainly. And also knowing who the point of contact is. So if questions come up throughout the transaction, that people are available at the law firm to answer that. When a deal closes and an issue comes up, we didn't disappear, we're still there. So it's all about service at the end of the day, you know? And both of our industries, unfortunately, you know, I hate to say it, but like 80-90% of the people don't give good service. And people just felt like they're a number and they're on to the next transaction. And it's building those relationships. That's the difference between wanting to work with somebody again or not.
Definitely. I think client experience is one of the most important things. And I think both of our businesses are very much repeat and referral. So they use this one time and they'll use this for life. And the reason being is because we do go above and beyond. It's not like we just turned ghost and they can't find us. They don't feel like the needy girlfriend or the needy boyfriend that's texting and not getting a response. I actually used that for a tradesman once upon a time. I messaged him and I was like, I feel like the needy girlfriend. I need you to come check this out. Please let me know what's going on. And everyone's experienced this at one point or another where
1,000%.
they reach out to people that should be there when you need them. And they just don't get a response.
And they write, I'm so sorry to bother you. And then when they get back a response right away, don't feel sorry. That's what I'm here for.
Exactly.
I'm here for you. Then they feel comfortable and it's building that relationship. You know, in any service industry, at the end of the day, we could be selling widgets. It don't matter what the good is, what the service is. It comes down to it is building that word of mouth. You could spend, you know, millions on internet advertising, on TV, radio. Word of mouth is where it's at. People that had good experiences telling their friends, family, coworkers, that's the best advertising ever because they know. They experienced it, and that's what you want other people to feel. Certainly.
Well, that's kind of why I refer you.
Well, I appreciate
like
it.
I pretty much introduce. Yeah, I should probably say that. Introduce
It's all about
you.
introductions.
But I do introduce you to quite a bit of my clients, and it's because I know the service that you've provided for me and the service you've provided for my clients, and I haven't had an issue. But I have had other professionals in the past where I've used, and I usually test them out on me. I'm the guinea pig. On me or on a family member, just because I want to see how they handle the transaction. If they do it well, then I would refer it to a client. If they don't do it well, I'm never referring them anyone because I expect whoever I'm sending them to give them the same skills and the same time and the same effort that I give my own clients.
It's funny, you and I were talking about this before we started our taping today and talking about how I'm doing a podcast now called The Chosen Life. Catch it on the Kormans YouTube channel. And part of the thing is, one thing is like, let's say you and I work together, Elena, and you're introducing people that know me through the real estate context, that's great. But even if they're introduced to me through you or they found me through Google, that's fine. But they also want to say, who is this person? You know, anybody can close a real estate deal. Anybody can be a lawyer. People want to know who is the person behind the person. When somebody goes on your Instagram page, they get a sense of what your personality is like. Can I relate to this person? I know when people get introduced to me, one of the first thing they do is they click on LinkedIn. They want to see my picture. Does he have a trustworthy face? Do I know him? Seriously, I've been told this. Then they read over my credentials. They may go over to Instagram. They'll try to see what my personality is like watching the video. And that's where when I put a podcast, it's everything to do but the fact that I'm really a lawyer. I want to show that I'm a real person. I relate to people. I connect with people on various levels because at the end of the day, I'm not just a lawyer. I'm a human being, and that's the connection point. And it's amazing in this day and age, you know, it's not just a symbol of having degrees, X number of transactions closed, do I trust this person? Can I relate to this person? And do I want to work with them? Period.
Definitely.
Yeah.
I know we've talked previously about what to look for when hiring a real estate agent, but what would you look for when hiring a real estate lawyer? What should people look for when they're looking for a real estate lawyer?
Great question. And I'll give you a very easy answer. So when I have a new lawyer that comes into my office, and let's say they just joined us, I tell them there are 4 secrets to being a good real estate lawyer. This can be on any level, on any type of job, but especially in our field, for sure. You have to have experience, and you have to have knowledge. When you're a new lawyer, you just don't have these things, so you better build them. Close a lot of deals, get to know the ins and outs. When people ask you questions, you'll be able to answer them. Great. Get results. Number 3, get the thing done. Somebody needs something done, you find a way, you get it done. Many people don't want to know how you did it, just get it done. How many people you have to consult? You have precedent? Did you have to do it from scratch? Do you know how to negotiate? They want the results. And number 4, people have to like you. And what I tell them is at the end of the day, if you have all the experience and knowledge in the world, but they don't like you, they don't want to work with you. If you get the results and your experience, but you're not likable, they don't want to work with you. Things have changed. It's not like it was 50, 60 years ago. This is my dad's lawyer. This is my mom's lawyer. This is the family law lawyer. This is the person that our family's always worked with, so come hell and high water, I'm going to work with this person. It's not like that anymore. It's, do I feel comfortable and do I want to be with this person? So the problem is in law school, they teach you law. They teach you how cases work. They don't teach you necessarily how to be a lawyer, how to get things done, and they don't teach you how to win friends and how to be a good person and how people to trust you. So when I have a new lawyer, one of the first things I tell them is go get the book on how to win friends and how to win people over. Learn to be likable. That's, I think, the most important criteria. Then from there, you have to get the results, certainly, because they can love you until the end of time. But if you're constantly screwing up their files, they don't want to work with you.
Definitely.
Get your results and build up your experience and knowledge. If you can have those 4 things, you are unstoppable. That's the key to being a real estate lawyer.
Amazing. Well, thank you again for joining me, Jonathan. Once again, it's Elena Saradidis. I had the pleasure of having Jonathan Hacohen with the Choice in Life podcast from Kormans LLP with me today. Thank you so much for joining me.
Thank you for taking the time for me today. This was an ultra pleasure, honestly. You and I have known each other now for a few years. We closed a lot of transactions together. It's nice to see you from this end of things. It's funny because we do like a 2-minute phone call, 10-minute phone call. We're always rushing, we're always going. It's nice to be able to connect this way and have people see what our conversations look like. This is truly how we speak, and this is how we connect on a personal and professional level. And looking forward to closing thousands of deals together in the future.
Definitely, this will be the year.
2022 is gonna be an awesome year.
Exactly.
Thanks,
Thank
everyone.
you again.